here we go. We're rolling now. Oh, Jake also did a backup recording for me. Nice move by Jake over there. He's a smart guy, but it is working. All right, our radio program intended to be for informational purposes only. This information does not constitute legal advice. The law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. So Marshall Chriswell on the line with us this morning. And Marshall, you were telling me this is National Make a Will Month or Day or Week. What is it?
It's, August is National Make a Will Month. So, a good time to for folks to think about having a will done. If you haven't, we know that statistics tell us that well over half of all adult Americans don't have a will, and those that do, many of them haven't updated them for years and years. So it's the month to think about it.
Well, it certainly is, and there have been some interesting things in the news recently about wills. The Naomi Judd will is a case that has gotten a lot of attention. What's going on with that? What are the issues that we need to understand that we can learn from that?
Sure. So Naomi Judd is, I think probably most folks know who she was. She's a country star, and she's got a famous family, right? 2 daughters, Winona Judd, another country star, and then Ashley Judd, who's also a pretty famous actress. And Naomi Judd tragically took her own life some time ago, and then just this week I started seeing in my news feed, on the phone that there were issues regarding her will, and I don't know if the algorithms thought that I like country music or I like estate planning or what, but it was showing me all these different articles, and so the interesting thing was that they were saying that her daughters had been cut out of her will, and all of these articles were speculating as to how upset the daughters might be because they had been totally cut out of Naomi's will. Mm-hmm. And so and I thought, oh, that's strange. So I clicked through, and so what if you go on to read the article, what it said was that the daughters had been cut out of the will because Naomi's current husband had been appointed executor of the will with, quote, full discretion to deal with her assets, real property, personal property. He had full discretion to deal with it all as the executor, and it just kind of stopped there. And all of these articles had been, had kind of come from one news source, and it was being replicated throughout media. But and I read that, and I thought, well, that's interesting because that is not what that means. And I think sometimes people get their terms mixed up, and even people that are trying to report news or purport to know what they're talking about get their terms mixed up when they're talking about wills and estate planning stuff. Mm-hmm. Just because her husband has been named executor of her will doesn't mean that he gets everything, right?
Right.
Right. And that's what all these articles were saying. He's the executor, so the daughters have been cut out. No, the executor of your will is the person who is appointed to manage your estate, to gather your assets, to pay your debts and final taxes, and then make distributions to the beneficiaries of your will.
So he is obliged to follow what her directions in the will say.
Absolutely. And so all of this speculation that, the daughters have been cut out because he's the executive, he is legally obligated. He has what you call a fiduciary relationship to her estate. He has to follow. Now he has the will gives him some discretion to say, okay, well, she owns a beach house here, a mansion there, has these different assets, and is he going to sell them or is he going to distribute them to the beneficiaries in kind, without selling them and just distribute the asset? Yeah, he's got some discretion to do that, but it doesn't mean he gets everything.
Oh, okay. All right. So sometimes those headlines are designed to make you read it, and you read it. So, Marshall, let's break down the terms here as we think about Make a Will Month. Executor. is the word that you have used most often in our conversation this morning. What are the considerations we need to take into account when we are considering an executor for our will?
Sure. A lot of people will choose a family member, a child. Usually when spouses make reciprocal wills, which is common, then you're going to name your spouse as your primary executor, which is all fine. You just want to make sure it's someone who is up to the job. If you and your spouse are both elderly and have health issues and things like that, maybe you want to think about your spouse not being your executor. An executor is someone who needs to be able to work closely with professionals like an accountant and an attorney to be able to manage the assets, to list properties for sale, deal with those types of things, to keep track of the cash that comes in and out of the estate, file tax returns, manage kind of the just the day-to-day operations of an estate. And there's a lot of work involved. And like I said, you're going to have an attorney involved. You're going to have probably a CPA, but there's a lot of work involved, and people don't necessarily realize how much work it is, and that you need a person with a certain level of competency to serve as the executor.
Now, beneficiaries, that of course is on the other end of it, but let's talk about that a little bit. There probably is an assumption by many that automatically, if there are 4 kids, then it will get split 4 ways, the assets of the person who has passed away. Naming their kids automatically means the kids are each going to get an equal share. Not necessarily the case.
Right. Well, you have to be, specific in the will. If you just list all 4 kids, you say my beneficiaries are my 4 children. That's fine, and that the will would be interpreted that the children would share the assets equally. It's certain, if there were things that you wanted to go to one child or the other, whether it's personal property, real estate, whatever, that wouldn't really be considered. It would just be an equal four-way split. But the other part of that is, if you just list the 4 kids and don't have any specific instructions, what's going to happen if one of those children predeceases you? Mm-hmm. Okay, what do you, and what do you want? We always have that conversation when we're preparing wills. Okay, if tragically one of your children predecease you, what do you want to happen with their share? And sometimes people say, well, I want it to go back to my other 3 children in this case. Okay, so that'd be everything divided in 3 equal shares, or do we want it to go down the line to your deceased child's children, or some other method of distribution? And so one of the things you want to do is really want to talk that through, because it's something that most people, when they come in for an initial consultation to discuss a will, it's something they haven't thought of.
Mm-hmm. Yeah, that's a very good point. There are things that we will not have thought of in terms of even assets. What is an asset, and what is the value of an asset? These are things that need discussed when you're talking about a will as well, don't they?
That's right. And one of the things that you really want to another thing that people don't think of are non-probate assets that won't be passing under the will. Brings us back to the Naomi Judd tale, right? If there could be, and very likely are, assets that Naomi Judd owned, such as maybe a trust with her daughters as beneficiaries, or real estate bank accounts or investment accounts with her daughters as joint owners. All those things would pass outside of the will. So even if, hypothetically, the will did say that her husband was the only beneficiary, there are all these assets that don't pass under the will, wouldn't go to him. They would pass according to the beneficiary designation or the survivorship that's related to joint ownership. So that's something that we also talk about, in that initial consultation is, okay, well, there are probate assets, things that are going to pass under the will. We want to deal with those in the will, but there are also non-probate assets. Let's make sure those are set up correctly. You've got joint ownership, you've got beneficiary designations. How are we going to set that up?
All right, so all of those are issues, and there are many, many more that need to be discussed and discussed in great detail before you come up with that final will. But as you've mentioned a couple of times here today, it begins with that initial consultation. And somebody might think, I have to have everything in a big gym bag, all my papers, everything that I have that I can account for, and take it to the attorney and have him or her sort through it. It's not that, is it? The initial consultation isn't meant to be that.
No, it's not. The way that I handle those is when someone contacts my office and says, I want to talk about, getting a will, putting an estate plan in place. I have a pretty simple questionnaire that I send out, and you fill out prior to meeting, and you bring that with you. And it gives me the information, the general information that I need to get the conversation going, right? Your information, your kids, other beneficiaries, who are these folks, where do they live, how old are they, that kind of thing. And then a general idea of what your assets are and how you want them distributed. So, but you do not need to come in with bank statements and retirement account statements and, your marriage certificate. I've had people bring in, all kinds of things like that. And to get the conversation started, we don't need that. And then if after we discuss matters and we decide, okay, we need some more details on some of these things, then I might give you some homework and say, okay, please bring me X, Y, and Z. But that first consultation is simple, and I try to make it as easy as possible because I want to get people in to create these documents because, like I said at the top, not enough people have them.
Yeah, absolutely. And the process of developing that will can be quite involved. It can be rather simple, and that will be determined as well as it begins and then runs its course. So if somebody wants to get started with you in preparing a will during this National Make-A-Will Month, what should they do?
Sure. Call me at 724-465-5826. Stop and see us. I'm in the old R&P Cole Building, 655 Church Street in Indiana. Or go online, drop us a message at www.westernpalawyer.com.
Thanks, Marshall.
Hey, thanks, Todd. Have a good week.